Yeah, so we would like to continue with our discussion of the discharge of contracts. I mean, we are almost done. So we are just trying to wind these things up so that we can have more time to look at few questions, and then we tell you about the exams we are writing. And I think you are good to go. And I must say that the things that we are discussing are not something new, because indirectly we'll be discussing them as we discuss some of the other topics. So I think that this is something that we can easily relate to as it were. So you shouldn't be worried about. We are sort of, as Ezekiel will say, we are doing like a mop-up. So we would like to use the first few minutes to discuss discharge by agreement. But just before we proceed, at our last meeting, we discussed discharge by performance. And just in case you didn't join that class and you've not been able to play back what we did, we have explained discharge to mean the various ways in which obligations that are assumed under contract come to an end. So when we say that a person has been discharged, it simply means that you are released from the burden of having anything to perform under the contract. So that's what we mean by like the discharge. When you enter into a contract, you assume obligation, right? You assume responsibility. So at what point are you released from those obligations? At what point are you released from the responsibilities? Now, when you are discharged, so question is, how do you get discharged? How do you get released from your burdens or responsibility? And we've noted that discharge may occur either by frustration, and frustration is what they call like if you like an operation of law in the sense that certain developments happen having entered into the contract, and the law says that as a result of occurrence of those developments, we should regard the parties as having been discharged, meaning that the parties are released by law from the burden or from the obligation to perform under the contract, right? Then we also said that contracts may be discharged by performance. And by performance, we noted that ordinarily, one will expect that parties to contract must carry out their mutual obligations. I do mine, you do yours, and everybody is happy. Nevertheless, in reality, it's not really like that. Only one side might have carried out a side, and another party has not. So how can we say that one has actually carried out a side, and for that matter, in the eyes of the law, he doesn't have any burden or he doesn't have any obligation to perform again? So, and that is what we mean by discharge by performance. So for that to really happen, the law has set a standard which you must measure up to, so that if your performance gets to that level, we can say that you have been released from your obligation to perform, or you are released from the burden to do anything under the contract. And we saw the precision rule or the exactitude rule, which requires that you must carry out exactly as you undertook to do under the contract, so to speak. And we saw how it is really strict with respect to either contract for goods or contract for service. And of course, over time, we also learned how the common law and equity evolved some exceptions in order to mitigate the rigor or the strictness of the precision rule. So we saw things like the doctrine of substantial performance, where you've carried out almost everything. Then the court said that, well, we should give you the contract price less the amount of money required to make good the defects in your performance. Or we also have what we call like the quantum merit. In appropriate cases, especially where you have what we call like divisible contracts, severable contracts, the obligations are such that some can actually stand on their own, independent of the rest. So where that is the case, and if carried out some obligations, we can stand on their own, independent of the rest of the other obligations. You could be given payment for that on basis of a quantum merit, as much as your performance is worth or deserved. So we look at all that. Then we also noted that where you are required to perform, but the other party, instead of giving you the free hand or space to to perform, for example, stands in your way. So it's prevent you from carrying out your obligation. Then, because you're prevented from carrying out your obligation, the law says that you'll be considered as actually having be released, because we're prevented by the other party, and so on and so forth. So these were some of the things that we discussed at our last meeting. I'm sure that Mr. Zikose has also been discussing it with you again in the tutorials. So tonight we want to talk about discharge by agreement. Of course, we've discussed discharge by breach already. Maybe when we finish, we just spend some 5-10 minutes on that, and then we know that effectively we've done everything about discharge, and that should mark end of all topics which are meant to be studied in law of contract anywhere in the common law world, and you should be able to compete with anybody as far as law of contract is concerned. Now, discharge by agreement, it sounds a bit weird in the sense that the argument will be that how can you enter into an agreement to end an agreement? Is that not circuitous? Some kind of like a secular reason. Secular reason is like you're going around, right? Yes, the basic principle of law is that what has been created by agreement may be extinguished or discharged by agreement. And in fact, agreement, therefore, as we will notice, becomes a very decent way for getting things done, for bringing things, some arrangements into being, and also in bringing arrangements to an end. So, and that is why the point is being made that discharge by agreement should let us remember the basic maxim that what has been created by agreement may be extinguished or discharged by agreements. So in practice, parties to an existing contract may enter into agreement to abandon the existing contract, right? Before both parties have actually carried out all the obligation. Let's actually sit down and then strike a deal so that we don't have to really worry ourselves about this particular contract that we made, as it were, and that can be done. That can be done. So let's keep that in mind. But the question which we are confronted with is what we have witnessed already when we are discussing consideration, if you remember. Because having an agreement to do something, either end or vary an existing agreement, is not anything new. You've met it before when we were discussing the doctrine of consideration last semester. So for example, we know that for agreement to be binding, it must have been in the form of like a formal agreement, which is under seal. So that by reason of the seal or by deed, it is considered as binding. right? Or if it is not a formal contract, but is a parole contract or a simple contract, then it must be supported by what? It must be supported by consideration, as it were. And we are still confronted with what we know in Ghana concerning the effect of the Contract Acts on the doctrine of what? Consideration. So that is all those things, I think we have to bring them to bear so that you look at our Contract Act, for example, and say that, well, if you make a promise and so on, even where consideration is not provided, it's still binding. Those principles are applicable also to discharge of contract by agreement, right? So let's keep that in mind. But another point to remember is that as to whether the issue of consideration, for example, even at common law, will really be problematic or not in terms of trying to determine whether a contract has been discharged, will depend ultimately upon whether we are dealing with like a bilateral discharge or a unilateral discharge. So let's keep that in mind. What do you mean by bilateral discharge? Bilateral discharge occurs when both parties to the contract have some right to surrender, right? Where when we say both have some rights to surrender, that's to say that you have A and B, right, to the contract. A has not finished performing all that is required of him. And obviously, should he perform, B is going to enjoy from that, right? So with respect to the current contract, B has a right under it. And the right he has under it is what A is supposed to what? Is supposed to perform, right? Let's also suppose that B is also required to perform something under the contract. And should B perform it, is going to inure to the benefit or advantage of what? Of A. So what we are seeing is that with respect to the contract in force, B has something to receive and A has something to receive. And what each of these parties have to receive is very much dependent upon performance of the outstanding obligation by either side. And for that matter, both parties could decide to surrender their right. So B could say that, I'm okay, A, don't do what they're required to do for my benefit under the contract. And A could also say that, okay, that is fine, B, you don't have to perform. So that way, both parties have mutually surrendered their right under the contract, right? Therefore, where the unperformed, we have like unperformed obligations, as I have explained, of the parties to the original contract, and each party provides consideration by agreeing to release his right under the contract in consideration of a similar release by the other. We say that there's a bilateral discharge. So A has asked B not to perform, right? Good. So A is promising B that, yes, don't perform what you are supposed to do under the original contract. If B would also agree that A should not perform what he's also supposed to do under the original contract. Now, that's mutual arrangement. That is like the bilateral discharge, right? Because each of the parties, as it were, have surrendered the something of value, as it were. So, in terms of the agreement for bilateral discharge, we could probably look at it from the point of view of, if you like, the three possible scenarios. So we can look at the scenario of the variation of existing contract, right? And for that matter, what we learned when we're discussing the rule in the Pinnel's case, if you remember, Fuchs and Beer, Section 82 of the Contract Act, 1925, mutatis mutandis are all applicable. And then rescission plus agreement on the terms of a new contract. Rescission plus agreement on the terms of a new contract. Rescission, as we know, simply means that you are canceling, right? You are canceling or you are repudiating a contract, right? Made. A contract whose obligations have not fully been carried out. You decide to cancel it out. You decide to rescind it. So that is rescission. Now, sometimes you may do that on the basis that a new contract should be concluded in place of the one which you are canceling or which you are nullifying, as it were, right? And the third scenario is like you rescind or you terminate the existing contract. You just rescind it, terminate it. You don't think of any new contract to replace the one that you are terminating or the one that you are rescinding, as it were. So all these possibilities are there, so let's keep them in mind. Then we also have unilateral discharge, right? Unilateral discharge happens where only one party to the contract has rights to surrender. That is to say that you have two parties, if you like, to the contract, and one party has completely performed his side of the contract. And that is to say that it's wholly executed on his side, right? And the other party is yet to fulfill all his obligations, meaning that the other party has got outstanding obligations. Mind you, we're not talking about breach of contract by the other party, right? Because it may probably not have been due in terms of time for performance for the other party, right? So therefore, we don't talk about breach. Breach only occurs where the timeline for performance has actually arrived or is due, and you fail to perform, in which case we talk about breach. Or, as we will notice in the case of what we call anticipatory breach, anticipatory, the time for performance of the obligation has not yet fallen due, has not yet arrived. And then you evinces a clear intention that you are not going to perform the obligation, as it were. So where that is the case, that's, of course, depending upon whether it is accepted by the other party or you affirm it and so on. So we are not talking about any of that as far as unilateral discharge is concerned. With respect to unilateral discharge, we are talking about where a party has obligation which is yet to be performed, not necessarily because he has breached it, no. Probably like the time for performance is even yet to actually fall due, as it were. Now, so where you have carried out your side and the other party obligation is yet to ripe for performance, you go out of your way and, for example, release him from performance. Release him in the sense that you say that you don't have to perform, and I'm not going to hold it as a breach of contract against you should the time for performance even arrive, as it were. So that is unilateral discharge. Of course, at common law, unilateral discharge, a promise by someone to release another from obligation under existing contracts, right, must be supported by consideration before it can amount to effective discharge. Now, we used to call that, what do you call it, the accord and what? Satisfaction. Accord and satisfaction. The accord is the agreement for the discharge of the original contract. And the satisfaction is a consideration upon the party who has performed his obligation, right? So you have performed your obligation, right? And the other party is yet to perform, but you agree that you are going to release the one who is yet to perform, right, from performance. So that is the unilateral discharge that we are talking about. So maybe if we needed the illustration, let's look at the case of British Russian Gazette and Trade Outlook Limited against Associated Newspapers Limited. Mr. Talbot agreed to compromise 2 actions of libel, which had been commenced by him by the British Russian Gazette in respect of certain articles in the Daily Mail. The Daily Mail is a newspaper in the UK. His promise was expressed in a letter in which he stated as follows, quote, I accept the sum of 1,000 guineas on account of costs and expenses in full discharge and settlement of my claim. And I will forthwith instruct my solicitors to serve notice of discontinuance or to take other steps to end the proceedings now pending. So this was, if you like, the what really happened. Now, before payment of the money, the promised money at the time, the 1,000 guineas, Talbot disregarded the compromise and proceeded with the trial of the case. And later on, when such a move was challenged, the court held that the letter recorded an agreement in which the consideration was a promise for a promise. In consideration of your promise to pay 1,000 guineas. So the defendants were therefore entitled to enforce the accord by way of what? Counterclaim. And this is quite common in our day-to-day engagement, especially when it comes to like law practice. Somebody, for example, will have like a cause of action against another person. You will sue, maybe a plaintiff will sue the defendant, probably for damages for certain things or trying to get some other things. And the defendant may also do counterclaim, like counterclaim saying that you have sued me, I've also sued you, right? Good. So at some point, probably some agreement may come up in which the plaintiff will say that I have abandoned all the reliefs, all the claims that I was making against you. Maybe in return for you also probably surrounding the counterclaim as it were. So that is how we're done. We've also talked about like, if you like a novation, another way in which discharge may occur. I've explained what you call like a novation earlier on. And novation, I think we've also met novation before. If you remember this case, the case of Hadley and Ponsonby, which is usually contrasted with the case of Still Cannot Marrick. If you read the text writers, especially Tritel, and then even Answer on Contract and then Session 5, they will make the point that the way to rationalize the decision by the court in Hadley and Ponsonby, having regard to the fact that the material facts or the situation in Hadley and Ponsonby, in terms of like the desertion by some of the seamen from the ship and all that, was not significantly different from the situation in Stilk and Marek. And you notice that in Stilk and Marek, the court said that the promise to pay additional wages to those who stayed behind and helped the ship to complete its voyage was not binding because of insufficiency of what consideration. But in Hadley and Ponsonby, if you remember, the court said that the promise also was binding. And as I said, if you read the text writers, some will allude to the fact that in the case of Hadley and Ponsonby, what you had was one of novation. So what is novation? Novation happens when two existing contracts are replaced by one, right? There's a contract between A and B. And then they say that let's abandon that contract, and in place of that, let us conclude another one. So novation comes from the Latin word novus, right? Novus. So novus in Latin means new. So later on, you are learning law of thoughts. There's a principle called the novus actus intervenus. So where you have like a new thing which has intervened, or which has come between the breach of the duty of care and then the resulting injury, right? To break the chain of causation. But that's not what we are discussing. I'm just trying to let you know the etymology of the word novation, which is essentially novus. Novus means new. So you enter into like, you end the existing contract, and while ending that, you enter into contract, which is in similar terms or whatever, replace the existing one, right? Yeah, maybe another point we may also made, which is can happen in reality, is condition subsequent. And condition subsequent, if you remember discussion by authors of Anson on contract, when we're discussing terms of contract, they talk about condition subsequent and precedent and so on. And then the case of a head and theta cell. So a contract may include provision for its own discharge by imposing a condition precedent, which prevents the contract from coming into operation unless the condition is satisfied. In other words, the contract may impose a condition subsequent by which a contract is discharged on the later happening of an event. That is to say that for the contract to remain in force, a particular condition or particular situation should remain true. Maybe we could probably even go to the example of the case of, I think the financing, if you remember the financing against Thompson, right? When we're discussing the revocation of offer or the termination of offer, where they say that where an offer has been made subject to condition, failure of which condition will mean that the offer has lapsed. So for the offer, for example, in that case, to remain, the condition on basis of which the offer was made should have remained. So that if that condition, for example, ceased to exist, then the promise or the contract, as it were, will also be said to have come to an end. So for example, if we look at the case of Aberfall Plantation Limited against the Chen, the parties entered into agreement in 1955 to sell and buy a plantation, which included 182 acres, in respect of which the leases had expired in 1950. The vendor had tried without success during the intervening years to obtain a renewal of the leases. Mind you, the leases expired in what? 1950. But the agreement was made in 1955. Now, if you look at clause 4 of the agreement, it provided that, quote, the purchase is conditional on the vendor obtaining a renewal of the leases. So the one who was selling the land, right, his title had actually elapsed by a fluctuation of time or had expired. So the understanding between the buyer and the seller was that we are making this contract for purchase of this land or whatever on basis of the condition that you will take steps to get the lease renewed. Now, what that means is that if he proved unable to fulfill this condition, that is, he was not able to renew the lease, then the agreement for selling the land will become null and what? Void. So that was the situation. And as the facts indicates, the vendor was not successful in trying to get the lease renewed. And for that matter, the court held that the purchaser could not recover the deposit he had paid as it were, because the purchase is conditional on the vendor obtaining a renewal of the lease. Yeah, I think we will end discussion of discharge of contract by agreement here. And as I said, we've already discussed discharge by breach, but it will not be out of place to just do a quick recap of that. Okay, so just a minute, let me open my mic. Okay, so we would like to continue our discussion by looking at the discharge by breach, and that should mark the end of discussion of the various ways in which a contract may be discharged. Of course, I have indicated that this is not the very first time we are encountering discharge by breach, because last semester when we were discussing remedies for breach of contracts, that was done on presupposition that we knew what a breach of contract was. And quite apart from that, we have also been learning terms of contract this semester. And among other things, we discuss the relative importance of what? Of terms, looking at the warranty, looking at the condition, and then the innominate term. And within the context of all that, we encountered a discharge, as it were. We encountered a breach. Just a minute. By the interruption. Yeah. So when we talk about the discharge of contract by breach, we have to remember that a breach of contract is said to have occurred where a party to the contract has failed to comply with his obligations under the contract, or has failed to perform his obligations, right? Or he has performed it in a defective manner. But we have to remember that it's not any breach of contract at all which will constitute discharge by breach, because we understand discharge to mean that you are released from federal obligations under the contract. If that is so, then it is important to also appreciate that it's not any breach at all, right, which will bring about a release from federal performance, as it were. Now, related to that, we should also remember, and of course, we've encountered that already when we're discussing remedies for breach of contract last semester, that breach of contract give rise to secondary obligation to pay damages to the innocent party who are suffered as a result of the breach. If you don't carry out your side of it, then automatically you are assumed, so you have an obligation. The primary obligation is what you are supposed to perform under the contract. You have failed.
The first part gets.
Please, mute yourself. Let me mute all of you. Yeah, so you have like the primary obligation, that is to do that which is required of you under the contract, but you don't do it. And your failure to do that primary obligation also brings another obligation, what we call like a secondary obligation upon you. And that secondary obligation is to pay what we call like the damages, right? To pay damages to the one who is innocent, who has carried out his side of the contract. So what we should remember is that when a breach of contract has occurred, we may identify two scenarios, because the breach may fall into one of two categories. And the primary obligation to perform the contract terms remains. So that one is very fundamental. So what are the two categories of breach that we are talking about? And these two categories of breach will entitle an innocent party not only to claim damages, but also to treat the contract as discharged. And what are these? One, where the party in default has repudiated the contract, either before performance is due or before it has been fully performed, right? So where you have repudiated the contract, meaning that you have elected, right? You have elected not to perform the contract, not to carry out your contractual obligation. And this election may be one of two scenarios. Either it is time for you to carry out the obligation and you defy that you won't perform, right? Or it is not yet time for you to perform, but you have evinced, you have indicated, you have manifested clear intention that should the time for performance arrive, you are not going to perform. Secondly, where the party in default has committed a fundamental breach, but of course, from discussion of the exclusion clause, I hope you remember the case of photo production against Securico and subsequent cases in which the view has been held that the fundamental breach doctrine has now become more of what they call a matter of interpretation rather than any fixated meaning as used to be the case in the past. Yeah, so we've talked about anticipatory breach, and the point we are making, or we've made already, is that it occurs where one party indicates or informs the other by words that is express or by conduct that is implicit that he will not honor or perform his contractual obligations should same become due. So that is why we say anticipatory, from the word anticipation, you're expecting, isn't it? Remember Charles Dixon's book, Great Expectations. Yeah, so expectation, anticipation. So anticipatory breach. Anticipatory breach in the sense that time for performance has not yet arrived, and yet clearly the other party has indicated that he will not perform should even the time even arrive, as it were. Now, this type of breach, that is anticipatory breach, will be treated as repudiatory because the contract is renounced or the party incapacitates himself from performing the obligation under the contract. The one who is supposed to perform has said that, yes, I won't perform, right? I won't perform. And that is why we're saying that it's a repudiatory in the sense that it releases the innocent party from the obligation to perform. And that was why in the case of Mercy Steele, Lord Blackburn, right, tried to explain anticipatory breach in a very beautiful ways. And let me quote the words of Lord Blackburn, quote, where there is a contract to be performed in the future, if one of the parties has said to the other, in effect, if you go on and perform your side of the contract, I will perform mine. That, in effect, amounts to saying, I will not perform the contract, right? If you go on and perform your side of the contract, I'll perform mine. So that, in effect, is saying that amounts to saying that I will not perform the contract. In that case, the other party may say, you are giving me the stern notice that you not perform the contract. I will not wait until you have broken it, but will treat you as having put an end to the contract. And if necessary, I will sue you for damages. But at all events, I'll not go on with the contract. Now, this is pertinent because when we're discussing what we call damages for breach of contract, we talk about the point of mitigation of what? Of damages, isn't it? That where a breach of contract has occurred, you have to take steps which are not unreasonable or which are not too onerous in order to mitigate, to minimize the losses and so on. So, for example, where anticipatory breach, for example, has occurred and so on, and you have accepted anticipatory breach, and if there's an opportunity for you to get what the other party was supposed to have done, and for example, you make use of it and to minimize the losses, then you go for it. So anticipatory breach, in effect, gives the injured party, that is the innocent party, two options. First, he can elect to treat the contract as repudiated by the other. As repudiated means that he can say that, okay, if you've made anticipatory breach, I'm taking it serious. I'm not taking it with the gloves. I'm not taking gloves. I'm not taking it as a joke. I'm taking you at your word that you've actually terminated the contract. So I'm going to sue you for breach of damages for breach of what? For contract, as it were. And all the other things that we know will kick in. Or the second option is that the innocent party can elect to affirm the contract. Electing to affirm the contract simply means that he allows the contract to continue until there's a natural breach. And that is to say that you have heard anticipatory breach, but you don't want to take it serious, right? You don't want to take it serious, and you rather want to wait for the D-Day to happen. For the D-Day to happen, because there can be a change of mind. Maybe bad example, but those of you who are familiar with the Christian Bible, the Lord Jesus Christ gave a certain parable, I think about a man who had two children, and he sent them. One told the father that I'll go, and he didn't go. And the other told the father in the face that I won't go. But later on, when the obligation was really due, he had a change of mind and what? Went. So anticipated breach, one might have said that I won't perform, but later on, there may be a change of mind and he or she may want to perform. And that is why the second option is also permissible, that you can choose to really ignore the anticipatory breach and continue to carry out your side of the contract, hoping and waiting for the time for performance by the other party, in the sure hope that he may perform. So that way, you have sort of ignored the anticipatory breach. And when you've ignored the anticipatory breach, in law, we say that you have elected to affirm the contract. There has been affirmation by you. Affirmation by you in the sense that you are not allowing the anticipatory breach to terminate the contract. You are still regarding the contract as being in force, right? And wait until the actual date or time for performance by the one who made the anticipatory breach. And a well-known case is the case of White and Carter Councils Limited against McGregor. The respondent sales manager, acting within his authority, entered into a contract with the appellant for the fixing to litter bins or plates, advertising the respondent's business. On the same day, upon hearing of the contract, the respondent wrote to the appellant to cancel the agreement, but the appellant refused to accept his cancellation and went ahead to display the advertisements. So the contract was for a period of 156 weeks. And under the terms of the contract, if any installment was unpaid for 4 weeks, the whole of the amount due for the 156 weeks or the remainder of that period became payable. The respondent did not pay the first installment within the time allowed, and the appellant sought to recover the whole price. And eventually, when the matter came to the court held that the respondent were entitled to succeed, and a dictum was made by on behalf of the panel that, quote, if one party to a contract repudiates it to the other, the innocent party has an option. He may accept that repudiation and sue for damages for breach of contract, whether or not time for performance has come. He may, if he chooses, disregard or refuse to accept it, and then the contract remains in full effect, right? So that is a White and Carter against McGregor. So let's keep that in mind. And of course, you've met the case of Rochester against the Bilateral. Remember, Rochester against the Bilateral, when we were discussing terms of contracts, the defendant engaged the plaintiff as a courier to accompany him to European tour, commencing on 1st June. On May 11, the defendant wrote to the plaintiff to say that he no longer required his services. So the tour was meant to start 1st June, but the anticipatory breach occurred on 11th May. Now on 22nd May, the plaintiff commenced legal proceedings for anticipatory breach of contract. And the defendant objected that there was no actionable breach until 1st June. And the court held that the plaintiff was entitled to sue as soon as the anticipatory breach occurred on 11th May. In other words, the court was reiterating the point which White and Carter against McGregor had made, that where an anticipatory breach has occurred, the innocent party has the choice. You can accept the anticipatory breach, right? And actually treat the contract as having been repudiated. In which case, you do what is done. When there has been a repudiatory breach, you sue for damages, you are released from further performance and all that. Or you can elect to affirm the contract. You elect to affirm the contract, meaning that you will ignore the fact of the repudiation, right? And think that the time for performance has not yet arrived. And for that matter, for you, you are not taking what the defaulting party who has given the notice of repudiation, you are not taking him serious because not yet time. So you continue to observe the contract as if everything is what is in order. So that is what we should remember, and that was exactly what the court came to in the Rochester and Bilateral. So the court made the point that if the innocent party elects to treat the contract as still subsisting, despite the other parties' anticipatory breach, then the innocent party may lose the right to sue for breach of contract if the contract is discharged for frustration or illegality. So if you decide to ignore the anticipatory breach, right, by affirming the contracts and observing your side of the contracts, hoping that the person who has evinced intention not to perform is really not going to be serious and he or she will have a change of mind. Now, during the intervening period, should anything happen, such as frustrating events, right? Then the frustrating event will inure to the benefit of the person who had evinced intention not to perform. In other words, should you ignore the repudiation, the anticipatory breach, and affirm the contract and behave that the contract is still in force? If there should be frustration, you will no longer be able to sue for damages, right? And you know that frustration releases the parties from or discharges the parties from the contract. And even the person, despite the fact that he had evinced an intention not to perform, so long as the time for performance has not arrived and frustration has a kick in, he'll be able to take advantage of the frustration, and you can no longer sue him for what? For damages. So that is the only risk should you decide to affirm the contract and ignore the anticipatory breach. So let's keep that in mind. And that is exactly what happened in the case of Avery against Bowden. A ship was required to load cargo at Odessa within 45 days, right? The shipmaster was told before the expiry of these days that no cargo would be available. Now, he elected to affirm the contract. In other words, he ignored the anticipatory breach and remained at the port, hoping that a cargo will be provided. In any case, the cargo was supposed to load within 45 days. So he thought that 45 days is quite a long time. Now, before the expiry of the 45-day period, the contract was frustrated by outbreak of war, which made it illegal to load cargo at the enemy port. And the court held that the ship owners could not recover damages for anticipatory breach in failing to provide the cargo since the master has affirmed. The master had ignored the anticipatory breach and behaved as if the contract was actually in force, waiting for the 45 days elapse. And since frustrating event, in this case, outbreak of war, occurred before the time for performance, the party which had made an anticipatory breach could take advantage of the frustration. You could no longer bring an action for damages against him. So that is a point that we should keep in mind. Now, so the takeaway is that where the innocent party makes an election to treat the contract as discharged or terminated, but that is, if he chooses, he's not affirming, he's not making affirmation, he's actually recognizing the anticipatory breach, then he must notify or make his decision known to the party in default. And the legal effect will be the following. One, he's not bound by his future or continued contractual obligation and cannot be sued on them. Two, he need not accept nor pay for further performance because the contract has been discharged. Three, he can refuse to pay for partial defective performance already received. And four, he can claim back the money paid to the defaulter if he can, and thus reject defective performance. And five, he is not discharged from the contractual obligation, which were due at the time of the termination. Yeah, so these are some of the basic legal consequences which flow from the anticipatory breach. Okay, now let's wind up by talking about actual breach. Anticipatory breach, as we have seen, mean that before time for performance of the obligation, the one party indicates that he will not perform, right? Either expressly or by conduct. That is anticipatory. Actual breach, on the other hand, from the word actual, meaning that time for performance has actually arrived and you fail to perform, you default to perform, you don't carry out, right? And the actual breach may occur in one of three ways. One, non-performance, that is, the due date of performance arrives and the other party does not perform its obligation or part of the bargain. Or secondly, you can have actual breach in the form of defective performance. That is to say that the performance does not measure up to the precision rule. If you remember the precision rule, which we met. Good. Coburn and Blanche and those type of cases. And then the third scenario is that untruth as regards a term of the contract, for instance, where the promise made by a party has deliberately concealed the true intention, then that could also be an actual breach in appropriate circumstances, as it were. Now, another thing we should note is that whether an actual breach can actually discharge the parties from their contractual obligation will very much depend on whether the breach is fundamental, right? And what do you mean by saying that a breach is fundamental? A breach is said to be fundamental if the term of the contract that has been broken is of importance to the parties and goes to the root, the very foundation of the contract. That makes it further performance impossible. In other words, that particular term is so important that the breach of it makes further performance of the contract impossible, so to speak. And that will be a fundamental breach, as it were. So we know already that terms of contract may be added condition or warranty, isn't it? And then the more recent addition, innominate term, thanks to Lord Diplock in the Hong Kong Fair case. Yeah, so I'm not going to belabor those points. So I assume that the discussion we did on terms and the recording are still available. You can go and look at the recording, especially the relative importance of terms and the things that we said about condition, we said about warranty, innominate term, they are still applicable here. We are not going to belabor that point. So that said, this will mark the end of like a formal lecture. And what we are going to do next is to discuss some questions, right? Before we will end. And Mr. Ezekiel Say has also been doing very well, having a lot of discussion with you, and you continue to do his best before you write the examination. Okay, so Mr. Ezekiel said, let me make him a co-host. I don't know whether my colleagues are here. Jennifer, please, are you here? Jennifer Sarah is not here. Let me see if my colleague, Mr. Daniel Buell, too, is here. Yeah, oh, Mr. Buell is here. Okay. Is that Buell?
Yeah, Doc.
Yeah, good evening.
Evening, Doc.
You have before we start the question, do you have any comments to make?
No, Doc. I don't have any comment.
Mr. Ezekiel, sir, you have anything to add?
No, sir.
Okay. All right. So let's take advantage and look at